Hello, my name is Brandon Silver and I'm a construction senior associate at Bexley Beaumont specialising in contentious and non-contentious construction law. Today I'm going to talk about the recent big news in the construction industry that ISG has gone into administration. Of course, this is going to be a big shock to the construction industry and remind them of what happened in 2018 when Carillion went into liquidation. Unfortunately, despite nearly over 6 years having passed since Carillion going into liquidation, the same thing has happened with a big player in the construction industry going insolvent. The question is, why is this happening? Now, unfortunately, in my experience, I am seeing a lot of companies in the construction industry going insolvent. I think the likely reasons for this is that we are facing the repercussions of COVID, labour and material costs are increasing, companies are pricing too competitively and then cannot uh, work towards their lump sum contract that they've agreed. They then try and agree a new sum with the employer. The employer, of course, says no and says you've entered into this contract and you've agreed this price. They simply cannot carry out the work for that amount. They're making a loss and unfortunately go insolvent. And unfortunately, it trickles down that when one company goes insolvent, then more are to follow. And unfortunately, I think that's what's going to happen in the current situation with ISG. I anticipate, unfortunately, that many suppliers and contractors and subcontractors down the chain are going to fall into insolvency as a result of ISG going into administration. Indeed, it's been widely reported that one contractor alone was owed 15 million from ISG. That's a significant sum of money, and unfortunately, I think will cripple them and no doubt also cripple other suppliers and subcontractors. The question is then, what can you do in such a situation? How can you mitigate your loss? What advice do we give to clients? Well, the advice we're giving to clients, mindful of the current economic situation, is that if you're not being paid, you need to take action. It doesn't matter what relationship you have with your client, how reputable the client is at making payment, what its financial history is. That doesn't matter. If you're not being paid, you need to take action. The longer you wait, the less bargaining power you have, and the weaker the position you are in. There are a number of remedies available to you, and I'm going to discuss them. But firstly, I'm going to reiterate how important it is that you take action as soon as possible. Taking the ISG example, let's say you're a contractor employed by ISG. ISG has now gone insolvent, and ISG owes the contractor £300,000 by way of example. You are a supplier engaged by the contractor, and the contractor and the supplier have entered into a contract, and one of the bespoke terms is a pay when paid clause. Now, a pay when paid clause will be, pursuant to legislation, unenforceable. However, and this is important, there is an exception to that rule. If the provision provides that the contractor will not pay the supplier until he is paid by ISG, in the circumstance where ISG is insolvent, there is no obligation on the contractor to pay the supplier. That will be enforceable. In circumstances where the contractor has not been paid by the employer because the employer has been insolvent, there would be no obligation, if such a bespoke provision was provided, to pay the supplier. This puts the supplier in a position where they won't be paid. So it's really important that if you're not being paid, you need to take action as soon as possible to avoid the situation where many suppliers and subcontractors are now in. So, what remedies are available to them? Well, the first remedy available is you could commence a smash and grab adjudication against the contractor. This is obviously subject to adjudication applying, and it's also, of course, subject to them not having paid by the final date for payment the notified sum and no pay less notice has been issued. Provided you can meet those requirements, then you could commence a smash and grab adjudication seeking a determination that they have failed to pay by the final date for payment a notified sum and that no pay less notice has been issued. If you get a decision in your favour and they still fail to pay, then you could commence enforcement proceedings and then, if necessary, if they've still not paid, potentially winding up proceedings. Alternatively, if the relevant individual is administrative savvy and has issued the relevant payment or pay less notice, undervaluing your assessment, but you believe your assessment is correct, then what you can do is commence a true value adjudication, again subject to adjudication applying. The difference between true value and a smash and grab adjudication is that in a smash and grab adjudication, you're being successful by way of default on a technicality, but if it's a true value adjudication, it is on your true entitlement. My advice is that if you are not being paid and they are being administrative savvy, which tends to happen with the bigger companies, then you need to make sure that if you're not being paid and you're not satisfied and you need to assist your cash flow, you bring a true value adjudication. It may be that this prompts them to pay you further money and the adjudication is halted. In order to assist the strength of your true value claim, you need to make sure you've always keeping good records and good evidence of the work undertaken. Take regular photos, videos. I'm also seeing people wear like GoPros on their helmets to record progress. Keep progress reports, programs, and the like to make sure that you've got enough evidence to show what the true value of the works is. In addition to relying on adjudication as a form of action if you're not being paid, you can also issue, subject to certain elements being met, you can suspend the works, and this is a very helpful tool to hopefully prompt payment being made. If you've issued an application for payment and they've not issued you with a payment or pay less notice in response, then you're entitled to be paid that by the final date for payment. If the final date for payment has elapsed and you've not been paid, then you can issue a 7-day notice of intention to suspend the works. If then payment has not been paid and the 7 days has elapsed, you can then suspend the works. By suspending the works, you're obviously then putting the companies upstream in a difficult position where this is causing delay and will hopefully prompt payment being made. The thing that you need to make sure, though, however, is that you definitely suspend the works lawfully. If you suspend the works unlawfully, this would amount to a breach of contract. You need to make sure that you're issuing the correct notice, following the provisions in the contract as to method of service, and making sure that 7 days has elapsed before you suspend the works. Another useful tool that can be done if you are have entered into a JCT contract is that you can issue a first notice of default to the employer, specifying that they have failed to pay the notified sum by the final date for payment, and pursuant to the terms of that contract, if a certain number of days passes and payment has not been made, then you can issue a second notice within a certain time frame terminating the contract. Of course, you would need to follow again the provisions of the contract in terms of method of service and also how many days is stated in the contract that has to elapse before you can issue the relevant notices. Now, very importantly, and this was a very recent case, it was determined that if you issue a first notice of specified default, but you never issue the second notice terminating the contract, that be it for whatever reason possible, be it that they have finally paid, albeit after the first notice, or simply because you've decided not to, then, if they again fail to pay by the final date for payment, they repeat that and don't pay a notified sum, then you can immediately terminate the contract because you've already issued previously that first notice and there's already been now a repeated specified default. This was a very significant case and provides contractors with great needed assistance in terms of cash flows. This is a very key step that can be used to hopefully prompt payment. My advice is that these kind of steps should be taken, action should be taken. You can't just continue with the works and hope payment will be made. You should try and suspend the works provided you can, and alternatively, bring a smash and grab adjudication if you can. Like I said, if however they're commercially savvy and very organised in terms of their administration and have issued the compliant and relevant payment and pay less notices, but are purposely certifying you less than your true entitlement, then commence that true value adjudication. Otherwise, you're going to have to continue working, not getting cash flow, and this is going to put you in a really bad financial situation. The final remedy available to you, but unfortunately is not that strong a remedy, is that you can, of course, claim interest if you're not being paid by the final date for payment, the notified sum. However, I often see a schedule of amendments with a bespoke amendment where the interest rate has been amended and it's much lower than what the standard rate is. And this means that there's no real incentive for an employer to pay because the interest rate is so low. So my advice in summary is take action when you're not being paid. Suspend the works, but make sure you follow the correct provision, follow the correct procedure and the method of service. Further, bring an adjudication, be it a smash and grab or a true value adjudication, depending on the circumstances and whether a payment or pay less notice has been issued. And also check the contract to see if you can issue some sort of notice of specified default, as that would trigger the termination procedure and enable you, subject to payment not being made, terminate the contract at a later date. Thank you for listening. If you have any questions, please let me know. If you're not being paid, we can help, we can give assistance, and we can advise you on what action should be taken. Thank you for listening.